Senate bill.
Senate Bill 233, a bill for an act being enacted by the people of the state of Oregon. Section 1. Notwithstanding ORS 12.1104, an action to recover damages for injuries to a person arising from, in connection with medical or surgical treatment, omission or operation of the removal of the hernia mesh may be filed within 1 year of the effective date of this 2025 Act of the date of the removal of the hernia mesh upon which the action is based on was on or after January 1st, 2018 and before January 1st, 2019. 2. This section does not operate to revive any cause of action that has been settled, compromised, or agitated before the effective date of this 2025 Act. Section 2. This 2025 Act being necessary for the immediate preservation of the public peace, health, and safety, an emergency is declared to exist, and this 2025 Act takes effect on its passage.
Thank you. The question now arises on third reading and final passage of Senate Bill 233. Representative Chaichi.
Good morning, Mr. Speaker.
Good morning.
Colleagues, today I rise in support of Senate Bill 233A. I'll explain what this bill does on a technical level, but first I want to begin with the personal story of Jim Evangelista, who brought this bill forward with Senator Manning. My office had the privilege of meeting with Jim when he came by before the bill was heard in House Judiciary. He shared his experience of how a hernia repair surgery in 2018 left him with years of debilitating pain. Pain that prevented him from fully engaging in life with his family and from his work at Reality Kitchen, a nonprofit he runs with his wife that provides employment skills, training for people with disabilities. Years later, after countless doctor's appointments and unbearable pain, he discovered that the surgeon had used non-dissolvable sutures. They became entangled in a bundle of nerves causing lifelong chronic pain. But when Jim sought justice, he learned that he was past the 5-year statute of ultimate repose, commonly referred to as a SOUR, and therefore he was unable to take legal action against the medical professionals whose negligence caused irreparable harm. Faced with no other option, Jim determined to offer his personal story and experience as evidence that this law should be changed to have parity with the other state negligence laws, including legal malpractice, product liability, and construction negligence that each have a 10-year SOUR. Like many Oregonians and myself, prior to meeting Mr. Evangelista, you may not be familiar with the SOUR. Unlike most states in Oregon, if a person learns of their medical claim more than 5 years after their treatment, they can no longer pursue legal action against the responsible party. In cases of medical malpractice, the statute of repose is 5 years unless fraud, deceit, or misleading representation prevented the plaintiff from filing within that time. If that's the case, the plaintiff is allowed an additional 2 years from the discovery of the fraud or deception to bring forward a claim. This is an unreasonably high burden carried by victims of medical malpractice. As we have seen in Jim's case, the effects of negligence do not always make themselves known until much later, and doctors often don't listen until much later. Oregon's 5-year SOUR for medical negligence is exceptionally short when compared to other states. As a result, attorneys often have to turn clients away because they became aware of their injury as a result of negligence after this arbitrary period of 5 years. This is exactly what happened to Jim and many other victims across the state. This is, at its core, an access to justice issue. Individuals should not be penalized for failing to discover medical malpractice before 5 years has passed since the initial instance of negligence. Senate Bill 233A will make a significant difference for individuals in situations like Jim's. The bill allows an individual to bring forward a cause of action within 1 year of the bill's effective date for claims related to medical or surgical treatment or the operation or removal of a hernia mesh, if the hernia mesh removal occurred on or after January 1st, 2018 and before January 1st, 2019. With our current healthcare system, where profits matter more than people, we know it can be difficult to even be seen by providers, let alone receive appropriate care. Then the 2020 global pandemic made it even harder for patients. The SOUR in this situation is simply not fair. I've heard concerns that this bill is too narrow, which leads me to believe broader reform must be more popular than the drafters of this current bill felt possible, and I hope people who think that will join me in addressing the SOUR later. While Senate Bill 233A provides a narrower fix to this issue, I am hopeful that we can return to fully examine and expand Oregon SOUR laws through a lens of justice and health equity. In the meantime, I strongly encourage an aye vote on Senate Bill 233A. Thank you.
Thank you, Representative. Further discussion. Representative Mannix.
Thank you, Mr. Speaker. To the bill.
To the bill.
My remarks are difficult for me because I am totally sympathetic to the issue which is being presented to us in terms of the particulars. I've met with Mr. Evangelista. He has a good cause to present. My no vote today is not out of any disrespect to him, but in terms of the principle of us changing a statute of limitations for a very narrow range retroactively, which will address a very narrow range of cases. If, as a matter of public policy, our statutes of limitations for any kind of recovery should be changed, they generally should be done prospectively, not retroactively, and they should be done broadly for a broad class of cases. If we're going to address the time limitations for bringing an action for medical malpractice, we should do so and have that broad issue in mind. Today, we're addressing a narrow issue. I trust this bill will pass, and I'm not encouraging anyone else to vote no. I'm simply explaining that I'm going to vote no because of its retroactive nature as to a narrow range of situations. And I'm sad to do that, but I think someone needs to just say, I'm standing up for a public policy perspective. Thank you.
Thank you, Representative. Further discussion? Representative Kropp.
Thank you, Mr. Speaker. Members, I agree with a lot of what I've heard in the two floor speeches today. I will say there are times in this body where we are motivated by an individual community or individual story to make a change in the law. And sometimes that individual story maybe represents something that needs to be changed for a broader group of people. I think about, we use the phrase sort of one-off as a disfavored term, but I can think anything from land use decisions that we've made in certain communities. I can think changing certain laws to be responsive to a situation that happened to an individual. I will also say there's a really clear example where something like this has happened before in this body. If you look at ORS 12.278, we had statute of limitations when it came to products liability cases. And in 1994, there was an incredibly tragic incident where a car accident resulted in an explosion because the car had a side saddle gas tank, and that happened in Madras, Oregon. That person would not be able to have sought any remedy because of the way our statute of limitations worked. In the 1995 legislative session, and I believe it was Bev Clarno from Central Oregon passed this piece of legislation that modified and created the statute ORS 12.278, which did carve out in our sort of products liability framework cases involving side saddle gas tanks. And speaking with Federal Senator Brzezinski, he sort of modeled this piece of legislation on examples of other pieces of legislation that we've done in the past. I'm not necessarily advocating that this is the norm practice, and I do agree with Representative Chaichi, maybe there needs to be a broader conversation, and I think I heard Representative Manning say the same thing, a broader conversation about our statute of limitations. I do think there's other examples where we've done something similar to this in the past, and I do think it's appropriate given all these circumstances that we vote in support of this bill.
Thank you, Representative. Is there further discussion? Seeing none, Representative Chaichi, you wish to close? She does not. Those for the opinion the bill should pass will vote aye. Those opposed, no. The clerk will open the voting system. Representative Scharf? No. Votes no. Representative Ruiz? No. Votes no. Representative Helfrich? No. Votes no. Representative Noce? Yes. Votes yes. Representative Bosshart Davis? No. Votes no. Representative Choatson? Votes yes. Representative Evans? Votes yes. Representative Nelson? votes yes. Gomberg votes no. And Senate Bill 2233, having not received the constitutional majority, is declared failed. Clerk will read the next bill.